Rise. The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. This court from recess now sitting. Please be seated. Good afternoon. Ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 3 p.m. docket.
Thank you, Your Honor. Please report. The first case on the 3 p.m. docket for Wednesday, May 8th, 2024 is appeal number 125508. State of Kansas Appellee versus Christopher D. Kemmerly, Sedgwick County, briefs both sides.
May it please the court, the appellate Christopher Kemmerly appears by counsel Hope Faflick Reynolds of the Appellate Defender Office, present and ready for argument.
And may it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Second case is appeal number 127197 in the matter of Mark A. Samsel, respondent, original action and attorney discipline.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. I'm present and ready for argument.
May it please the court, Mark Samsel, the respondent, present and ready for argument.
Your Honor, that concludes our 3 p.m. docket.
Now ask counsel in 125508, State of Kansas versus Christopher D. Kemmerly, to please come forward.
May it please the court. Hope Faflick Reynolds of the Appellate Defender Office appears on behalf of Christopher Kemmerly. Chief Justice, may I please reserve 3 minutes for rebuttal?
3 minutes is granted. Thank you.
Thank you. More than 61 years ago, the Supreme Court of the United States decided the landmark case Gideon versus Wainwright, establishing a right to counsel. In that case, it proclaimed that attorneys in criminal cases are necessities, not luxuries. Nevertheless, decades later, when the state of Kansas charged Mr. Kemmerly with serious felonies, including murder, he stood at trial alone. I'd like to focus today on issue 1 in our brief, which concerns this right to counsel and how it was violated in Mr. Kemmerly's case. We raised 2 ways in which the district court erred in honoring Mr. Kemmerly's right to counsel. The first is in the advisement that took place in 2021 before the district court allowed Mr. Kemmerly to represent himself. The second was when the district court denied Mr. Kemmerly's assertion of his right to counsel mid-trial. Let's start with the advisement that happened in 2021. There's some guiding principles that I think are important to keep in mind when we discuss this issue. The first being that the responsibility of securing an advisement lies squarely with the district court. The second is that in assessing this issue, appellate courts have been clear that we indulge a presumption against the waiver of the right to counsel. That's especially important in this case because of the unique history and circumstances that it presents. A year and a half before this advisement that was at issue, Mr. Kemmerly represented himself briefly at one hearing. Prior to that self-representation, the district court provided a full advisement consistent with the low factors. But when Mr. Kemmerly changed his mind and asked for a lawyer in the same hearing mere pages later, the district court granted that request and he received the assistance of counsel at that hearing and for another year and a half before he sought to represent himself again. At that,
You agree, I'm sorry, do you agree that that first advisement in February of 2020 satisfied the requirements of state versus burden in addition to Lowe?
the four factors required by state versus burden, is that what you're asking, Your Honor?
I think there were three, but nonetheless.
Yeah, yes,
It
Your
would-
Honor, but we're not challenging the first advisement from 2020. Our issue is solely with the second advisement that happened much later, in which the district court judge warned Mr. Kemmerly that managing discovery would be difficult, not only because it was extensive, but because he would remain incarcerated while awaiting trial, where he told Mr. Kemmerly that it would be up to him to figure out how to do what lawyers do in cases, which would be difficult because he was incarcerated during trial. He reminded him of that, and made a finding that Mr. Kemmerly had already received an advisement and was experienced in the criminal legal process.
But this was after Mr. Kemmerly had already advised this very judge in this case at that time that he was familiar, didn't need another Lowe hearing and didn't need to waste the time. So do you have any reason to think that he didn't remember everything that he had been told in February of 2020?
With respect, Justice Wilson, that's not the question. The question is whether he was reminded, whether he was provided adequate warnings and advisements before he waived that right to counsel.
With respect, that's my question.
Okay, so the record doesn't show that he doesn't understand, but the burden, to be clear, is on the state and on the court to create that record. At no,
Do
yes,
you have any reason to believe that he didn't remember everything that he had been advised in February of 2020?
no, I do not have something in the record to demonstrate a lapse in memory or that he did not recall that hearing.
So how often would he be required, do you assert that the judge has to repeat all of that each time a request to self-represent is made?
The ideal rule, I think, would be each time somebody seeks to represent themselves, each time somebody seeks to waive the important right to counsel, they should be advised of the risks involved with that decision. A helpful example might be in a plea context. When somebody enters a plea agreement, we engage in a plea colloquy each time. If that plea is later withdrawn and then a new agreement is reached, the district court does the plea colloquy anew because the right to trial is being waived in that situation.
Do you have any case law that says that is required each time?
No, Your Honor.
So I understand the record correct. So are you suggesting then there was an initial valid advisement and proceeds pro se, but then there's a change in circumstances when he's like, well, pause, I need assistance of counsel. And then from then, I think that was for the post-trial motions, et cetera. And then you go back for retrial. And if he wants to proceed pro se again, based on that intervening circumstance of requesting assistance of counsel, there needs to be a full advisory again, anew, so to speak, because of that intervening circumstance?
Yes, Your Honor, because he requested and received assistance of counsel in the interim. What I think is especially important in the second advisement is that Mr. Kemmerly was never told, if you ask for an attorney, you might not get one. He was never told, having once changed his mind and asserted a right to counsel before, he was not reminded or told again that he might not get an attorney, that if an attorney was appointed, that attorney would not be allowed a continuance in which he or she could catch up with the case. Those were not warnings that Mr. Kemmerly received after having exercised his right to counsel in the almost year and a half between the two advisements.
Is that one of the low factors? I really just can't remember.
Um,
That if you ask for an attorney later, you may not be.
I believe so, but I'll double check.
Oh, it's okay. Continue with your argument.
Okay.
I can.
The other thing that I think is important to understand is that this appeal is from Mr. Kemmerly's second trial. At his first trial, he received ineffective assistance of counsel.
Yeah, I was going to ask you about the procedural, kind of the history of this. He had an initial trial,
Mhm.
was found guilty, or some or all the charges. Then he moved pro se for a 1507, represented himself and prevailed.
Yes, Your Honor. He had assistance of counsel in the 1507 motion alleging ineffective assistance. It's at that post-trial hearing that Justice Wall asked about that the first advisement took place because he asked to represent himself in the midst of that hearing. That's volume 59 of the record.
And he did then proceed to represent himself for the remainder of the 1507. Is that how that worked?
He only represented himself for less than 10 pages of that hearing.
Okay.
It was at the same hearing on the motion about ineffective assistance of counsel that he asked for the assistance of his attorney again.
Thank you for the clarification.
Yes. So this is the second trial at which he represented himself throughout trial. And the motion to represent himself was considered and ruled upon well before trial began. His second request for counsel came mid-trial. And this court's case law is clear that those mid-trial requests will not be granted if there's a purpose to delay or obfuscate or some other nefarious, malevolent purpose. That's not what the record suggests in this case. The record suggests confusion about whether or not Mr. Kemmerly was entitled to counsel. It requests that he was struggling to represent himself in that moment with evidentiary issues. But again, the advisement that preceded this self-representation did not provide an adequate warning for that. So this request, I think, illustrates the deficiencies with the advisement that was provided in 2021 before Mr. Kemmerly represented himself at trial.
Can you address the tension that's there between the request to represent oneself, which is guarded and protected by case law, federal case law, and our Constitution, versus the very argument you're making here today? And how does the district court weigh all of that when the warnings had been given, and the absolute right to represent himself? I mean, you might be here arguing just the opposite had it been denied, or had his request been honored and counsel been appointed. So where do you land on that, or how do we address that?
Yes, they are interrelated rights, like Your Honor is pointing out, self-representation and the right to counsel. The default, however, is the right to counsel, and we are to presume against the waiver of that right. An assertion of self-representation is a waiver of the right to counsel. It is both exercising an affirmative right and waiving a clear textual fundamental right that should be safeguarded by our system. Because of that, I think it makes the process of an advisement more important. Because those are the two rights at issue, we really need district courts to make clear findings. We need them to ask questions about the state of mind. At the advisement challenged here, there's not a single question that the district court asks about, do you remember the prior advisement? What is your mental condition like today? There are no findings of that nature that happen at the second advisement. It is cursory, it is quick. And while I understand wanting to move through things, and maybe there's an assumption that Mr. Kemmerly understood, the district court should have taken the time to be more thorough and make sure that he had weighed and considered the risks and consequences of his decision to forego counsel and represent himself on murder charges.
In going to what happened during trial, we talked about the defendant's absolute right to represent himself so long as he understands that right, and his right to counsel is knowingly and voluntarily waived. But there is persuasive authority that holds the right to then obtain counsel after that is not absolute and within the court's discretion. Would you agree that that standard should apply here?
Yes, Your Honor, we're not challenging the standard for mid-trial requests or requests to change one's mind about those rights. However, I would note that the bulk of those cases where somebody is not entitled to counsel after insisting on representing themselves have to do with a request that is made for some nefarious purpose.
Do you think that his request for counsel mid-trial was unequivocal? Or was it equivocal? The state claims that it was equivocal because he said, well, because I want counsel because I'm being stonewalled. And so do we even need to decide whether it was equivocal or unequivocal?
My reading of the record is that it's a clear request for counsel, and I don't think, even if it is equivocal or made in frustration, I think that is a valid and adequate invocation of the right because of the nature of what is at stake and the nature of the right itself.
Did he have counsel representing him as standby counsel at that time?
No, Your Honor.
So it was made on the 5th day of trial.
Yes.
And persuasive authority indicates that if it is a substantial interference with the trial, that's one acceptable exercise of the court's discretion. Do you think it would have been a substantial disruption of the judicial process in this case if the court had granted his request for counsel if it was unequivocal?
It certainly would have been disruptive, Your Honor. We're not saying that asserting a right to an attorney on day 5 of a trial is ever ideal, but that again makes the advisement more important and is another reason to illustrate the importance of that initial advisement to make sure that the decision is entered knowingly and understandingly with a full appreciation of the possible consequences and risks of proceeding alone.
The best argument that it was an abuse of discretion.
That which part was an abuse of discretion?
That the judge said, no, I'm not going to give you counsel at this point.
That it was unreasonable in the moment to deny him an attorney.
And why is that?
Because he should be entitled to an attorney when facing murder charges, just like every person should be entitled to an attorney when facing criminal charges of any kind, like decided in Gideon versus Wainwright.
Is that an argument that it's absolute? And not an abuse of discretion?
The abuse of discretion is the denial of the right to an attorney.
Because no matter what, because it's a murder case, he should have had counsel appointed.
Your Honor, in any criminal case, any felony criminal case, he is entitled to the assistance of counsel, which has been firmly established for 61 years. Chief Justice, I see my time has expired. May I briefly conclude? In conclusion, this court should not allow the sound of Gideon's trumpet to fall silent, but should safeguard the right to counsel in this case and in others that other generations may hear its call. Thank you.
May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas. I will address issue 1 unless this court directs me otherwise. And I want to begin by saying that the state does not disagree that the right to counsel needs to be safeguarded. So does the right to self-representation. When it is asserted prior to trial, a request for self-representation that is unequivocal has to be honored so long as the defendant enters a knowing and voluntary waiver of the right to counsel. And here, the district court ensured that the defendant did enter such a waiver. I would begin by noting that this court has repeatedly held, and I cite Burden in my brief, that there is no set checklist for what's required in order to secure a knowing and voluntary waiver. And the reason for that is set forth in Burden, is that because we have to examine the circumstances in each case. Different defendants might be more capable than others. The state is of the position that the defendant in this case demonstrated himself exceptionally capable. It is in reading this trial, it's frankly a little bit difficult to imagine how much different or how much better a defense attorney could have done for him. The result was dictated by the evidence, not by his representation of himself or the district court's appropriate advisements here. I want to make one point very clear, and that is, to begin, the defendant's focus here is in his brief was only that third burden factor, whether or not the advisement was appropriate. There was some comment about whether or not the defendant was capable or competent. That's not before this court today. Burden factors 1 and 2 are not before this court. And frankly, even if they were, it is unquestionable on this record that the defendant was well aware of the charges against him, having gone through a previous jury trial, after which he himself filed a pro se motion alleging ineffective assistance of counsel that was granted based on what he alleged, frankly. The only help he got in litigating that motion was just going through the process, having that other person there to do the same things that the defendant had already alleged that he felt were failures of his initial counsel. And so I guess there was a little bit of a question about the timeline here. And so I do want to briefly touch on that to be clear what we are talking about. Defendant was convicted his first trial in November of 2019. He filed his motion alleging ineffective assistance approximately 1 month later. Then in February of 2020, there was, as the parties agree, a full low hearing conducted. And then we had some delays with the 2020 pandemic. We get to July 8th and defendant files a motion for self-representation. He was very clear in that motion itself that he has the right to represent himself. He is mentally competent. He displayed an understanding of the law. And at that point noted only that he wanted his 1507 or his post-trial counsel as, quote, an advisor or on standby in case he wishes to continue with court-appointed counsel in the future. However, just 5 days later, he then writes to the court, quote, "Your Honor, I will be moving pro se. I will not be dissuaded from exercising that right. I do not need to have a low hearing. I will be formally waiving that. We do not need to waste record space." So what we have, and is evident even this far back in the record, is we have a defendant that frankly is trying to set traps, set pitfalls, pose catch-22s for the court. He's unequivocally asserting the right, then maybe asking for standby counsel, but then in the very next breath, he's saying, but that very same standby counsel, you know what, he's actually not doing everything I want at this point. He may be ineffective. And so then that brings us to the July 2021 hearing, whereas the state set forth in its brief, again, while there is absolutely no requirement for a specific checklist, the district court here went over roughly 70 to 80% of the low factors which were suggested in that opinion. There was no question the defendant understood everything that was going on. He even had 5 motions on file that he was ready to proceed on right away at that time. After going through all of those advisements, then we had 2 hearings in August, 3 in September, 1 in October, 4 in November, and then trial began. And at no point did defendant ever again make a request for standby counsel, appointment of counsel. He litigated this case again, just as effectively as most if not all, defense attorneys would have.
Do you agree he did not have any standby counsel at the time of trial?
I agree. That's correct. And I would just again note, that's because he made the clear and unequivocal request before trial that he wanted to represent himself pro se. And therein lies the tension that was asked about. The court doesn't have a choice. If it believes that the defendant has made a knowing and voluntary waiver based on the inquiry that it conducts, it doesn't have a choice with this pretrial. With one exception that was identified in the U.S. Supreme Court case of Ferretta, where a defendant has demonstrated that he's going to be so disruptive to proceedings that he can't be allowed to act as his own counsel. But here, this defendant gave absolutely no indication to that end. He gave only indications to the contrary, that he was a very effective advocate on his own behalf. So again, just briefly on the test, there's no question he understood the right to counsel, including appointed counsel, and then he could change his mind. He had done that during his post-trial motions. After being advised of Lowe the first time, there's no question he knew the range of potential punishments and all of the charges against him. He'd even had the benefit of seeing his PSI, which is almost unheard of in these kinds of scenarios. The only issue was whether or not he was properly advised, and the state again asserts that he was, for all the reasons that we put in the brief. Justice Standard, you asked the question about whether he was told that if he asked for an attorney, he might not get one. That is not a Lowe factor. That is not one of the factors that's listed in Lowe. But then that leads right into where we end up with the second request during trial. I would note this tension between the right to self-representation and the right to counsel has to give way to some practical use. We have to be able to get cases to and through trial. And that is why once a case begins trial, once a defendant proceeds to trial pro se, the only question is whether or not the district court abused its discretion in denying a subsequent request for counsel. Here, the state would point out, as we have in our brief, the defendant's request was equivocal. I wanted to highlight actually one. Just factually, how it came about. The defendant was he was examining his sister during, he was conducting a direct examination of her. And he began to try to wander into claims of ineffective assistance of counsel, asking her to try to comment on what his counsel in first trial had done. And the state objected. The district court sustained that objection. But notably, he was successful. And maybe he didn't even notice in the moment, but in getting his sister to testify that, look, I was only able to answer questions based on what I was asked. That's really what he was driving at. And so then there's a recess when the jury is taken out of the courtroom. The defendant gets upset, curses at the court. The court explains why it had ruled the way that it did. Court resumes, and the defendant makes a remark under his breath. Aside from my request for counsel, the district court asked, "I'm sorry." And he makes, again, an equivocal statement that aside from my request for counsel because I'm being stonewalled. He's upset about one issue, a non-issue. And that's why he made his request, again, evidencing him setting traps. There's no basis to assert that the district court denied this late request on the 5th day of trial evidence because it abused its discretion. It acted soundly within its discretion because it was extremely late. It was clearly intended to be disruptive, in addition to being equivocal in the first sense.
What's your best argument that it was intended?
I think there are 2 points that are worth noting. Number one, the equivocal nature of it by tying it to a dispute that he had with the court's ruling, saying, I'm being stonewalled. Again, He's accusing the court of mistreating him when the court has done everything in its power to try to treat him fairly, to try to respect his request to represent himself. And then again, I think the timing here is telling. It happened immediately after a heated exchange. It was about a very narrow point in the trial and questions that were irrelevant, but that he was ultimately able to flesh out what he was seeking. So there was no point to it. Just to be a nuisance at that point, respectfully. Unfortunately, and I won't go too far into it, but my friend on the other side has recently, and this court recently had to deal with a similar situation when we were faced with how we get here today. This case was moved based on a letter not filed with this court necessarily, or even filed as a motion, but making allegations against my friend on the other side. It happened within days or weeks of our first setting in this case, and it caused an issue that brings us then here today. I think, again, we can see a pattern over time with this defendant as well. So I guess I actually had 3 points to answer your question.
Would it have been disruptive?
Extremely. Again, we are on the 5th day of trial evidence in the defendant's case in chief. For a defense attorney to have tried to prepare to represent defendant effectively at that point and avoid what would have been, I think, fairly obviously an inevitable claim of ineffective assistance, they would have at a minimum needed to get up to speed on all the trial transcripts, read the voluminous discovery, probably would have needed to go back all the way to the first trial and get those transcripts as well. But I do understand that those had been prepared. It's hard to say how much time that would have taken. Defendant having lived through this trial, and he still took about 7 months to prepare. And again, he knew the facts and was able to prepare in 7 months and represent himself effectively. It would have been a disruption, not only in the sense of the resources that it would have required to appoint counsel at that point, but also the incalculable amount of time that it would have required at that point. If there are no other questions, the state would stand on its brief regarding issues 2 and 3. We would simply ask that this court recognize that unfortunately we have a defendant in this case that does seek to be disruptive. That has been demonstrated repeatedly in this record. And despite that, the district court here did a sound job applying this court's precedent to make sure that the 3 burden factors were all addressed. They were all addressed. This is a defendant that knew exactly what he was doing. And despite even trying to dissuade the district court from engaging in a second low hearing, the district court pumped the brakes, did its job, and respected the defendant's right and safeguarded his right to self-representation. I ask this court uphold defendant's convictions. Thank you very much.
May it please the court? I'm prepared to waive rebuttal unless this court has questions I can answer.
Court will take this matter under advisement. I thank both counsel for your arguments this afternoon. We'll now call 127-197 in the matter of Mark A. Sampson.
May it please the court, Matt Vogelsberg appearing on behalf of the Disciplinary Administrator's Office. Madam Chief Justice, I'd like to request 2 minutes for rebuttal. Thank you. This is an original action in attorney discipline involving the respondent Mark A. Samsel. Mr. Samsel was admitted to the Kansas bar in 2010. On October 31st of 2023, the ODA filed a formal disciplinary complaint concerning two matters, DA 13-711 and DA 13-748. On November 9th, Mr. Samsel filed a timely answer admitting to most of the allegations contained in the formal complaint. Thereafter, the parties decided to forego a disciplinary hearing and instead enter into a summary submission agreement on December 7th of 2023 pursuant to Supreme Court Rule 223. Parties have stipulated that Mr. Samsel's actions violated KRPC 8.4B, committing a criminal act that reflects adversely on a lawyer's fitness, 8.4G, engaging in other conduct that adversely reflects on a lawyer's fitness to practice law, and 8.4E, stating or implying an ability to influence improperly a government agency or official. Because the parties have entered into a summary submission agreement.
Can I ask about those violations real quick? I might get them out of order, but B, E, and G were under 8.4. One covers criminal act, which is the conduct that was pled to in this case. One covers influencing government agency, which is the letter to the Department of Education attorney. And then I can't remember, is it G or E? I get them confused. G, that's any other conduct that adversely reflects on fitness. I'm just wondering, in interpreting that rule, the any other conduct, does that, it seems to me that we could interpret that as any conduct that's not actually covered in B and E. So if it is covered in B and E, G arguably would not apply. Do you know what I mean? Because of that other conduct language, or am I how would you respond to that interpretation of the rule?
My understanding from talking to Deputy Disciplinary Administrator both, and then also looking at Mr. Samsel's answer, that the 8.4B and G violations related to the first complaint, DA 13-711, and then obviously the E violation, improperly influence, was the letter, the second complaint. The theory was, how we were proceeding was the B was related to the convictions, and then G was related to the other conduct in the classroom that may not have arose to a level of criminal conduct, but still reflected adversely on his fitness to practice law.
Okay, so you're not necessarily arguing that's not an improper way to interpret the rule, but that the evidence actually fits that there is other conduct.
Correct.
Okay, gotcha. Thank you.
I was going to go into just because the parties we've entered into the agreement, the primary issue before the court is whether the court agrees with the recommended sanction of a stayed 1-year suspension and then placing Mr. Samsel on probation for 1 year. In order to give some context to the rule violations and the recommended sanction, I would like to give a brief summary of the facts. It's important to note that when respondent engaged in the conduct underlying both of these complaints, he was serving in the Kansas House as a state representative for the 5th House District. In the first complaint, DA 13-711, involved an incident that occurred on April 28th of 2021. On that date, Mr. Samsel was working as a substitute teacher at Wellsville High School in an art class. And while suffering from what his psychiatrist later described as a manic episode with psychotic symptoms related to a then undiagnosed bipolar disorder, Mr. Samsel caused a scene in the classroom when he told students that, quote, that he had the floor and that the class was going to, quote, be the most uncomfortable class of their life. Mr. Samsel proceeded to tell the class that God was speaking through him and then spoke about the God, devil, suicide, mental health with the art class. T, who was a student in Mr. Samsel's class, Mr. Samsel believed that T was being disruptive. And at one point, Mr. Samsel grabbed T from behind and picked him up. Later, he shoved T into a wall. And at a later point, Mr. Samsel told T that he was going to kick him, quote, in the balls. And then shortly thereafter, kicked T in the groin area. After kicking T, he told another student in the classroom, quote, check T's nuts for him. Mr. Samsel grabbed another student, JG, by the shoulders and asked her whether she had mental health problems. Mr. Samsel's actions caused JG to believe that Mr. Samsel was going to hurt her. The situation Mr. Samsel created made several students uncomfortable, causing them to leave the classroom while this was going on. Mr. Samsel was arrested by law enforcement the next day. He was ultimately charged with 3 counts of misdemeanor battery. On September 13th of 2021, Mr. Samsel pled guilty to 3 amended charges of disorderly conduct, all Class C non-person misdemeanors. He received 12 months of probation with an underlying 90-day jail sentence, and he successfully completed his criminal probation. Parties agree that Mr. Samsel's conduct relating to the classroom incident violated 8.4B and 8.4G. The second complaint, DA 13748, concerns Mr. Samsel's actions in responding to the Kansas State Department of Education's attempt to have his emergency substitute teaching license revoked due to those actions in the classroom. On June 15th of 2021, Dr. Michelle Miller, Director of the Kansas State Department of Education's Teacher Licensure and Accreditation Team, filed a complaint to initiate proceedings with the State Board of Education to revoke Mr. Samsel's substitute teaching license. Attorney Scott Gordon represented the Department of Education in the matter. Mr. Samsel represented himself. On July 30th of 2021, Mr. Samsel emailed a letter to Mr. Gordon and 2 constituents of the Department of Education, Dr. Randy Watson, the Commissioner of Education, and Dr. Miller, the aforementioned Director of Teacher Licensure and the Accreditation Team. The letter Mr. Samsel sent to the 3 individuals was significant because despite the licensure matter having nothing to do with Mr. Samsel's service as a state legislator, the letter was written on his legislative letterhead. Throughout the letter, Mr. Samsel referred to his work as a legislator and implied that based on his status as a legislator, the Department of Education should consider working with him rather than taking an adversarial position against him regarding his substitute teaching license. Ultimately, the respondent stipulated that this conduct violated 8.4E, implying an ability to influence properly a government agency or official. The ODA believes that the recommended sanction of 12 months of probation is appropriate, given that Mr. Samsel's conduct, while serious, was caused by him suffering from bipolar disorder, and that the probation plan is designed to ensure that Mr. Samsel continues to receive treatment for his mental health that, according to his treating psychiatrist, since February 16th of 2022 has been successful in keeping the symptoms of his bipolar disorder in remission.
Counsel, can I stop you and ask you a couple questions about what you were just describing? And I think you said a direct quote from the summary submission, which I think is little I2 in the mitigating factors on page 15. It starts at the bottom of page 15. The mental disability caused the misconduct. And then there are a number of paragraphs that recite the substance of the doctor's testimony, or maybe it wasn't testimony, but statement.
A letter, and it's Exhibit A.
Okay. My question really goes to all of this, but it strikes me that the bulk of this, if not the entirety of it, is describing the causal connection between the mental health of the respondent and the April 28 incident. But I'm having a hard time seeing the connection between the mental health state of the respondent and the second complaint. Can you help me or maybe walk through that? Because even just the underlying facts don't strike me as conduct that is typically associated with a bipolar mental state.
In Exhibit A, which is Dr. Garrett Lambert, who's the treating physician, he explains that the manic phase that Mr. Sam was going through was still taking place as of July 30th of 2021 when the letter was written. And also included in his letter was noting that as part of this manic episode that Mr. Samsel was experiencing, I think, and I might be incorrectly paraphrasing, but the doctor said that the manic symptoms also Samsel as a result displayed delusions of grandeur, and so I would argue that those symptoms may have resulted in the self-importance that was shown in the letter that was written to the.
But self-importance is not that's not really what the violation alleges that he was bringing undue and inappropriate pressure to bear on KDH, the Department of Education. Is that right?
Yes.
That actually strikes me as a very rational, calculated effort to use one's position of influence to reduce possible consequences. Not as something that's influenced by delusions. It doesn't strike me as delusional at all. Yeah, I'm just trying to connect those dots. That's
Maybe the decision to write such a letter was that because of his bipolarism, he was more amenable to making that decision. The legislative letterhead and to refer numerous times to his actions as a legislature to benefit. That would be my best explanation for that.
Council, do you have any more, do we have a more current medical assessment than Exhibit A dated October 2023? And I'm just,
We do not from Dr. Lambert.
anybody, I'm just trying to get the medical
Right.
side of this thing. Or at least, I guess maybe what I'm trying to do is get the compliance with the medical regimen.
Right. Part of his KLAP monitoring agreement includes routinely seeing Dr. Lambert. I just spoke to Cal Williams, who's serving as his KLAP monitor. Cal Williams has assured me that he is in full compliance with his plan. That was just as of last week, but I have nothing in writing.
And that monitoring agreement and the probation plan, by its terms at least, looks to expire of like April of this year. It has expired. And I think that the agreement says that there's an agreement to continue the monitoring plan throughout probation. But I assume the parties also intend to extend the probation plan beyond that term as well, but I didn't see that language explicitly, but I assume that's the agreement. Of the
Yes, I
parties.
mean, the parties would, I would imagine Mr. Sampson would be in agreement to continuing the terms of probation for however long this court ultimately orders him.
Your deal, I got a little confused going, your deal that you're monitoring.
1 year.
Is that paragraph 36 of the summary submission agreement? Or maybe it's 37. Is there anything in the terms of the summary submission agreement that aren't already incorporated in the probation plan or the monitoring agreement? Or are those just sort of a summary of those terms in those two documents?
I believe all the terms from the submitted probation plan are included in there. I'm not for sure if I don't believe all the terms of the monitoring agreement. Actually, maybe C. But I believe that the intent of Deputy Disciplinary Administrator both was to include all the conditions by reference, at least from the probation plan and the monitoring.
But there's no new terms, so to speak, in the summary submission agreement itself. It's,
As far as I know,
Yeah.
they're not.
Can you remind me what happened in the underlying criminal case?
He pled guilty to 3 counts of disorderly conduct in September of 2021.
Battery?
No battery.
And disorderly conduct, and so what was the sentence?
It was 12 months of probation with an underlying 90-day. In conclusion, the ODA would ask the court to accept the party's summary submission agreement, impose the party's recommended sanction of a stayed 1-year suspension, and place Mr. Samsel on probation for 1 year, subject to the conditions laid out in the summary submission agreement. Questions for me?
Good afternoon, Your Honors. May it please the court. Mark Samsel, the respondent. First of all, I want to apologize. It is my conduct that got all of us here today and used the court's time and resources of everybody else here. As you've seen a lot of in the documents, it was 99% or more a manic episode from a bipolar disorder I didn't know I had. And if you would have asked me to tell you what bipolar disorder was before this stuff started, I couldn't have told you anything. It started actually a few years before any of this that is before you today. It started with cycles of depression that went on for weeks and months at a time. I started seeking treatment at that time. Wasn't later diagnosed until way on down the line that it was bipolar disorder instead of depression. So we treated depression, thought we beat it, and this cycle continued. And so to address one of the justice's questions, a very good question about the length of time between the first incident and the second incident. That's, as I learned, mania can go on for weeks or months at a time, especially when your brain is in that elevated, agitated state. And Dr. Lambert mentions this in his letter that's in the record in more detail, but just very briefly, I was attending those criminal proceedings. And then, of course, I was unfortunately also a state representative at the time, so it was highly publicized and agitating more than perhaps just a regular proceeding had you bipolar disorder. So my brain was continually staying in that agitated manic mode. By definition, when you're in manic mode, that means you're not able to identify you're up in that state of mind. So that was the length of time, Your Honor. The first time was in the classroom, and then yes, weeks and then even months later, as I wrote that letter, I thought God was calling me to still make this an event to bring attention to mental health. I obviously was wrong in hindsight, but at the time I thought I was correct. That's why I made the mistake of putting it on state letterhead instead of a personal letter, something of that nature. And I regret that I did it, and I apologize that I did it. I don't know that my intent was ever to try to influence them. I honestly was just trying to communicate with those two individuals, and the attorney, I don't know, for whatever reason, didn't really want me talking to them, even though I thought I had the right to, since I was the defendant. But if the court has any questions about that, I'm happy to answer those. I also want to thank Mr. Vogelsberg for stepping in today. Amanda Voth did an exceptional job working with me. I appreciate her professionalism. I appreciate KLAP and my monitor, everybody who was involved helping me through this process. It has not been an easy process, but it's one that I'm very thankful. I had a great career leading up to this incident. I worked with some wonderful attorneys that got to mentor from up at the law firm in Kansas City while this bipolar stuff was going on unknowingly and then after the fact. So I got to learn from some of the best. And I'm very appreciative of everyone in that who's also supporting. But I guess for today's purposes, though, we're asking you to approve the SSA. To address the justice's question about the criminal proceedings, I did apply for a diversion at the time on the basis that it was a manic episode. I think they made the right decision in denying that because I was still manic while I was making that application to the court. So we went through the process then. I worked very closely with the district attorney, as I've tried to with everyone. I guess it would be helpful for the court to know, I think finally in about September of 2021, when the criminal proceedings, we finally reached that agreement, my brain finally was able to come down from that manic episode that it was in, because that's when the agitation, the news proceedings, all of those things had finally slowed down and stopped. And my brain not only returned to more of a normal level, if you will, but then started dipping down into the depressive state over the course of days, weeks, and months. And that's finally, thank goodness, I regained my wits enough to listen to Dr. Lambert as he's saying, I think you've got bipolar disorder. We need to try some different treatment for that. We tried a couple medicines that did not work. Of course, with mental health, it takes weeks, 2 months, 3 months in order for those medicines to start taking effect. So for 2 or 3 months, the first one did not work. Same with the second one for another 2 or 3 months. So it wasn't until, as counsel mentioned, February 22, we went with old school lithium. That's the gold standard, which I did not know at the time, but thank goodness it has worked ever since then. So I have not had a single symptom, either manic, depressive, ever since that medicine finally started working in about February 2022, right around that time frame. So a little over 2 years now.
Let me ask you, looking forward, assuming we were to do the probation period, all that, what would be the nature of your law practice?
Good question, Your Honor. Not much different than what I've been doing recently. I did, to be honest with you, for a time as all that was going on, I pretty much shut down my law practice completely because mentally I wasn't in a good spot to be doing it. And of course, and that's what was leading to some of these things. So I actually took, it was a very humbling experience. A warehouse job that I did back in college just to keep things going and very minimal law practice. Once I got on the treatment and the lithium was working, I went back to more of like a part-time 2 or 3 local clients who I enjoy working with, construction clients, business contracts, collections, disputes, those types of things for them. And I've kind of been doing that ever since then. And then just more recently, it's been a little bit more of that. I tried to work with my doctor and make sure that our track moving forward was something that was consistent with me still having the bipolar symptoms fully in remission, which it has been, but that would be my intent moving forward, is still about 20 hours per week of doing business contracts, things of that nature, construction.
Solo practice.
Yes, sir.
And does that, do the agreements have, you have an attorney supervisor at all? Or is it all just geared towards ongoing mental health treatments and?
Good question, Your Honor. We actually considered that, but we decided, looking at the history of it, and if the court wants us to do that, we could certainly reconsider it. But we decided with the KLAP monitor and just making sure my health stayed with my treatment, if that was in order, we didn't necessarily see any other, it was never per se a practice issue. It was my behavior that was causing the issue, which was mostly unrelated to the practice, if that makes sense. Unfortunately, I don't mean to excuse that behavior because it was terrible, but. I think that's all I had, Your Honors. Again, I do deeply apologize. It was embarrassing, not just for me, but for everybody involved, the state of Kansas, the bar, and everybody else. I have done my absolute best as I've moved through, especially once I got back to where my mental health was back in my normal state. To be very transparent with it, very honest with it, as difficult as it might be, but try to help others with mental health in the profession. They still don't know what causes it, but I would bet quite a bit that I think it was cumulative stress and burnout from the law practice itself. Of course, then you throw on the state representative stuff and some other things, but certainly have learned a lot through this process. I'm happy to do whatever the court, KLAP, the disciplinary administrator's office would like me to do moving forward. But it is, I mean, as much as I wish this whole thing could have been avoided, I'm trying to do my best to use it for as much public good as possible. As you saw in the record, I did actually go to some length of writing that article for the Kansas City Star, of kind of giving my not only public apology, but this is kind of the transparent things of, as crazy as it sounds and it was, of the classroom and all the other stuff, this is how the brain got in that condition where you didn't even realize those were the things that were going on. So in closing then, unless the court has any questions, we would ask the court to approve the summary submission agreement, and I thank the court for its time.
How are you doing now?
Your Honor, I've been doing great ever since the lithium started working 2 years ago. And honestly, I actually honestly enjoy the practice of law again, which for even 3 or 4 years prior to the incident leading to this, the depressive cycles and the other things that had started, it was not fun. And I was seeking help with my mentors and others within the law firm and professionals, and we just didn't know what it was. So that whole cycle, in hindsight, if there was a way that I could have learned more about mental health earlier, I wish the whole bar would know that type of stuff. But ever since, Dr. Lambert has been amazing. He was actually a former law practitioner, and he was smarter than me and got out of the practice of law, then went back to medical school. But following his recommendation for lithium, which he's told me, you know, going by the book only works about 10% of the time in mental health, but that is what has done the trick for me. If I ever get any inkling, or as my parents or family or friends, as I told them, if you ever get any inkling that I'm off base, please, 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 not only tell me, but my doctor or whoever you need to, because this whole experience is not one anyone would ever want to go through. Thank you, Your Honors.
Unless the court has any questions for me, I would wait.
So thank you to both of you for your arguments. The court will take this matter under advisement. I'll reiterate, just for those that might be listening, that the court's docket has changed to accommodate the memorial services for Justice Six that are scheduled for tomorrow. So the court will not be hearing cases tomorrow. We will resume at 9 a.m. Friday morning.